work in this area, you realize that some of the most complex and difficult issues relating to how the duty to consult and the regulatory state fit together arise out of some of the major projects that the federal government has regulatory power over in respect of, such as the major pipelines that are getting built, both eastbound, southbound, westbound, and projects such as the oil sands, export licenses, the Mackenzie Gas project. These are all major projects with significant regulatory frameworks around them, which typically raise immensely difficult issues of consultation. And Dan works with the group that helps to manage this issue and to deal with these things. And finally, on my far left is Sandra Gogal, who I have to mention is a fellow Newfoundlander and part of the contingent that are busily running Canada secretly, and is a partner at Miller Thomson here in Toronto. She's practiced in Newfoundland and in Ontario. Her work focuses on advising industry groups with respect to, in particular, industry and proponents with respect to how to deal with Aboriginal issues, as well as litigating cases on behalf of corporations caught up in Aboriginal affairs. And I think currently is involved in a rather lengthy case for one of the Ontario power entities. She has written and spoken extensively on Aboriginal issues, having lived through them in Labrador, Newfoundland, Ontario, and elsewhere in Canada. So with that, I will turn it over to the panel, who will be addressing you in the order that you see.
Okay, well, thanks very much for inviting us to speak today. This is I think the first sort of broad panel on consultation for the next couple of days. We're not going to try and cover everything about consultation in our hour or hour and a half that we're here before lunch, but we'll try to give you a few overviews. So what we decided to do is divide up our presentations into three sort of sections based on what the program said we were going to cover. I'll give a quick overview of the duty to consult. By no means will it be exhaustive, but just to set the framework for our talk, and then hopefully people will also be responding to it and adding to it over the next couple of days. And then I'll be addressing a spelling error on cumulative effects and also on accommodation. And then Daniel will be talking about the role of tribunals and strength of claim, and Sandra will be giving a perspective of industry on consultation. Nope, that's the pointer. There we go. No, that's we've turned it off entirely. Okay. Oh, it's that. Okay. All right. So the duty to consult. Again, I'm not going to go over HIDA in any depth, but just to set the framework for the next couple of days, and as Robert mentioned before, HIDA is really the first articulation by the Supreme Court of Canada in a thorough way about the duty to consult from the 2003-2004 decision. There's debate over whether it's purely procedural or there's a substantive aspect to it, but it certainly gets triggered procedurally when the Crown's contemplating an activity that could adversely affect an Aboriginal or a treaty right held by a First Nation. So you're talking about a variety of decisions or actions by the Crown that will result in a potential adverse effect on a treaty right or an Aboriginal right. It's prospective looking. This isn't about sparrow and justifying infringements. This is about trying to look ahead and is it in the honor of the Crown to allow this activity to go forward without, and part of that was, well, let's chat with the First Nations, let's get their perspective, what are their interests, and let's see what sort of mitigation and accommodation is possible to happen. It's very important to understand that it's not just about physical impacts. First Nations are forever being asked, as Robert was saying in his presentation, well, what's the site-specific problem that you have? Do you hunt there? Is that a moose kill site? Have you camped there? And trying to limit it to these very discrete physical impacts. Those are important, but landscape management is also important. Wildlife management is important. And those have elements of higher strategic level land use planning aspects to them. And HIDA was about that very issue. It was about the transfer of forestry licenses and as a domino effect that would ultimately result in infringements of asserted Aboriginal title. But it wasn't an actual cutting permit to harvest trees or to dig a hole or anything like that. So we have to remember that there's a whole spectrum of decisions or actions that the Crown can take that are subject to the duty to consult. The tricky part, and this is where it's a real moving target, is the sliding scale that the courts set out in HIDA, which is that the scope of the duty isn't a concrete box that you can say, okay, here's your checklist. It depends on the strength of the potential claim, if it's an Aboriginal right, or the nature and scope of the treaty right, if you're dealing with an existing treaty right. And so you have that well, what's the strength of the right or the claimed right versus the seriousness of the potential impact. And you have this sliding scale that has to be assessed in terms of determining what the scope of the duty to consult is actually going to be. So with any kind of moving target, it's easier for the court to tell us that principle than it is to actually apply it. And that's where the messiness comes in with actually applying the duty to consult. And it's a dialogical process. There has to be engagement between the Crown, the First Nations on both of these issues. What's the nature of the right, whether it's asserted or existing, and what's the seriousness of the potential impacts? And you sort of need to have a dialogue about both of those things in order to properly assess the degree of consultation that's required, the kinds of mitigation or accommodation measures that are appropriate. Now, this is where I'll be able to talk a little bit more about some of the other cases that have come up recently since HIDA. The Crown's duty to consult lies upstream of the statutory mandate of decision makers. This is a point that comes out of the West Moberly case, although it builds on an earlier case, also from British Columbia, the Halfway River case from 1999. One of the challenges in consultation that's emerged is that statutory decision makers say, well, I give out forest permits, so I'm here to consult with you about a forest permit. And that's what I do, that's what we're here to talk about. And the First Nation says, well, really what we're worried about are all the roads, not the actual cutting permit per se, but all the roads that are going to increase access, which will allow the sports hunters to come in and hunt all of the moose in the area. And the forest statutory decision maker says, well, I don't approve the roads. Those are approved by somebody else. And so I can't address your interest, even though roads are going to have to lead in and out of the cut block. And very often, the result will be that the statutory decision maker will go ahead and approve, and they may or may not note that the interest of the First Nation was about actually the roads and less about the cutting in that particular spot. But they're not able to do anything about it, or they don't do anything about it. And this is incredibly frustrating for First Nations who see the Crown representative coming to them and saying, well, you're representing the Crown. We're the First Nation. Our relationship is with the Crown. We told you our interests. If you're coming to us, then you should do something about it. And, of course, the statutory decision maker says, well, I can't. I don't have a mandate for that. So in West Moberly, the Court of Appeal in British Columbia said, this duty lies upstream of the statutory decision maker's statutory mandate. The Crown is a large organization, multi-jurisdictional, multi-departmental, and it's not unreasonable that if your forestry person comes out and is the person who's consulting, and they have to go talk to a transportation person, back in the capital or back wherever these departments are housed, they should do that. And that's part of the honor of the Crown. The Crown can't sort of sit in its silos, however it's divided itself up, and say, well, that's it. We can only talk about what exists in our silo. The constitutional duty transcends the silos that the Crown is used to organize itself. The next issue is that third parties are under no obligation to consult, although procedural aspects may be delegated by the Crown. Now, this does come from HIDA, but one of the interesting things that's happened since HIDA has been how this has been implemented. Some companies take the position that they don't have to consult at all, they don't have to talk to the First Nations at all. And that's usually at their peril, because if there's not a relationship between the proponent and the First Nation, things are unlikely to go well. Some Crowns have taken the position, well, we'll make the companies do it all and we'll just call it procedural, because it's just a procedural right that we're dealing with anyhow. We don't have to, and so we're not going to bother sending any of our people out. We're just going to I'll tell the proponent, you go out and do all of our work for us. And then the First Nation and the proponent don't get along. Well, it's the Crown that gets sued, because ultimately the Crown has the liability, not the proponent. And then the last situation is where you get a little bit of consultation by the Crown, a little bit of consultation by the company, but each are sort of looking to the other to take the lead, and neither one of them really does, and it's sort of like ballroom dancing where nobody actually does say, right, this is the step we're going to do, and so you just step on each other's feet. And in the West Moberly case, this is an example of that, where the company decided to implement a caribou mitigation plan to address the First Nations' concerns about the effects of a coal mine project on a caribou herd. And rather than the Crown, rather than making its own independent assessment of the situation, said, well, we'll just rely on the company's mitigation plan. When it got to court, the court said, well, that was all a very nice mitigation plan, but it didn't really address the First Nations issues. And the Crown was left sitting there with relying on what the company's efforts were, but not to its without having to do any of its own independent work. And the court found the Crown to be lacking because it didn't step up to the plate. So I want to talk about two key themes that are emerging in consultation. One is cumulative effects. This, in the Rio Tinto case, which came out of the Supreme Court of Canada in November of 2010, it was, again, rose out of British Columbia, and it was about a dam on a river that happened about 50 years ago. And in a utilities hearing process, the First Nation wanted to raise consultation issues, and they said that there were, with respect to the infringements that this dam caused previously. And the Supreme Court of Canada said, you can't use these past wrongs as a trigger for the duty to consult now. You have to be looking at potential adverse impacts going into the future. But past wrongs are not properly subject to consultation. They may be subject to an action for infringement. This, now, in the Beckman case, which was also Little Salmon Carmax, was also released in 2010. And in that case, the Supreme Court of Canada said that the historical context, however, is always important in terms of understanding the present situation for consultation. After Rio Tinto came out, we saw provincial crowns and sometimes the federal crown saying to First Nations, we don't have to ever consider the cumulative effects of development in your territory when we're considering a particular application or a decision going forward. We can pretend that it's a pristine wilderness and that you cannot raise cumulative effects. We won't engage you on cumulative effects, and that's just all there is to it. In the West Moberly case, it was the first time that an appellate level court had been able to consider the Rio Tinto decision and the spin that was being put on it by the Crown and by the coal company in that case. And the BC Court of Appeal said, no, understanding the past, the present, and the future is all part of the context of the duty to consult. And you can't pretend that it's a pristine wilderness if in fact it isn't. The key here is that there has to be a causal link between the potential impacts of that proposed activity and the historical impacts that form the context. So you can't use a present proposed activity to rectify the wrongs of the past. That's inappropriate. But in order to understand the true impacts of a present proposed activity, you have to have an appreciation of the historical context. The last point that I'm going to address in this part of the presentation is accommodation. And this is in HIDA, the language was the duty to consult and, where appropriate, accommodate. There hasn't been a great deal of litigation about what accommodation means. Most people have taken it to mean avoidance, mitigation, that sort of a thing. And I think that by no means is there any closure yet on or understanding of what accommodation actually entails. It could be very wide. In the cases that I've cited here, we've got some additional aspects to consider for accommodation. First is the serious consideration by the Crown of the First Nations position. Mikisew talks about the no blowing off steam part of consultation. You just can't invite First Nations to come in the room and rant and rave about their concerns and then ignore them entirely. There has to be meaningful engagement. And that was picked up in the West Moberly case, where the BC Court of Appeal said, you know, if the First Nations put forward accommodation measures and concerns, the Crown actually has to engage those concerns specifically. It can't say, yes, we've listened to you, and now we're going to talk about what we want to talk about to begin with. They actually there has to be meaningful engagement. There has to be a meaningful dialogue. And if there's no evidence of that dialogue, it's open to the court to overturn that decision, which is what happened in West Moberly. The last case on that page is Adam, and that may not be a case that comes, I mean, it's actually three First Nations in Alberta who sought an order in federal court last year to require the federal Minister of the Environment to recommend to the federal cabinet to seek an emergency protection order for the boreal caribou herds in northern Alberta. And it was a judicial review primarily based on interpretation of the Species at Risk Act. But what was interesting there was that the First Nations made submissions to the federal Minister of Environment saying, look, we have treaty rights and we have a right to hunt these animals, and we're very concerned that you're not doing anything to protect these herds so that we can continue to hunt them. And the minister's response was, I don't need to consider that. That's not a relevant factor. And the Federal Court of Appeal said, no, you actually have to take into account the treaty rights of these First Nations and the honor of the Crown when interpreting the particular provision requiring consideration of an emergency protection order of the Species at Risk Act. So that's the last point there, that there may be strategies that the Crown has to consider or even legislative initiatives that come out of the consultation process. And at that point, I'll stop and turn it over to Daniel, and then hopefully there'll be lots of questions at the end.
Good morning, everyone. It's a pleasure to be here this morning, and I thank the conference organizers for the invitation to come and speak to you today. Nice to be in Toronto, too, where it's a bit like springtime in Ottawa right now. It's like springtime here, not quite yet in Ottawa. And I guess I should say from the outset that I'm here today expressing my own views on some of these issues. I had to sign a form to that effect when I applied to come to the conference today. So just so you know, I am expressing my own views, not those that necessarily represent those of the Government of Canada or the Department of Justice. But my views are informed by my role and my experience as a federal lawyer in the Aboriginal Affairs portfolio with the Department of Justice for the past 5 years, working in the area of Aboriginal law and specifically on consultation issues. And as Mr. Janes said, as they arise in a number of major resource projects that the government is currently involved in, including the Mackenzie Gas Project and now the Northern Gateway Project and others like that. I was going to speak today about a couple of, I guess move to the first slide. A couple of very important cases. One, of course, it's familiar to you, the Rio Tinto Sekani case, because I think it's probably one of the most important cases that have come down since HIDA, and it continues to have a great impact and give rise to many questions about its influence on what it means about the duty to consult, and about the aspect that I want to talk about with you today briefly, and that is the role of administrative boards and tribunals, what role they play in the duty to consult and in consultation, which that case had a lot to say about. The other interesting case that has come out recently is that of Adams Lake out of BC, which, and the reason it's of great interest to us in the federal government who are providing advice is for its focus upon the strength of claim analysis and this shift away from focusing so much on the impacts of a particular project on Aboriginal rights to looking at the rights at issue and understanding them. So I'll hopefully get to that one. I don't know. It's awfully hard to boil some of these issues down to a quick talk, but let's just jump right into the Sekani and the framework that it set up for determining the role of an administrative board or tribunal when confronted with Section 35 issues, Aboriginal rights issues. And just to sort of summarize for you, I'll in my view, just the decision in Rio Tinto, or Sekani as it's called, the Supreme Court of Canada has made a clear statement concerning the important role to be played by administrative boards, commissions, and tribunals in assessing the adequacy of Crown consultation when that issue is properly brought before them. The administrative law cases such as Paul and Conway that are referred to by the Supreme Court of Canada point to a trend in the law whereby administrative bodies find themselves legally obliged to consider important legal questions that previously weren't considered to be within that body's area of specialization or expertise or comfort zone or their specific legislated purpose. The obligation to consider legal questions concerning, for example, constitutional rights, in a case I was involved in involving human rights legislation or the constitutional duty to consult, arise from simply and most basically from the power of administrative agencies, boards and tribunals to decide questions of law. And that power will be found either explicitly or impliedly in their legislation, and it will be found to be necessary to the work of most administrative tribunals, in my view. So the decision of the Supreme Court of Canada sets out sort of a four-step test or analytical framework to determine what role any given board will have. It said a lot about the BC Utilities Commission in the Sekani case, but these are general principles that will apply to the analysis of any particular board or tribunal that you care to look at. And we have, over the past year and a half, looked at a number of them, including the National Energy Board. We were asked to look at specifically how the Sekani opinion or decision affects the role of the National Energy Board. We've looked at the Canadian Nuclear Safety Commission. We've looked at even smaller regional boards like the Mackenzie Valley Land and Water Board. And all of these, in my view, have the obligation to deal with the consultation issues, whether or not the duty to consult arises, whether or not consultation has been adequate in the course of their hearings, when and if that issue is properly before them. So the first step is to look at the empowering statute of the board or tribunal you're interested in. They are creatures of statute, and so all of their powers are derived from their statute. You then must assess whether the decision or the matter being considered by that given tribunal triggers or gives rise to the duty to consult. And so those three factors that come out of HIDA are very important. Is there Crown conduct? Is there a nexus with Section 35 rights issues? And is there a potential adverse impact to those? If those things are within the purview of the administrative body, then those consultation issues are raised by a party before them, that administrative body will likely have to deal with it. You then, Sekani says, Supreme Court said in Sekani, you then look to see whether or not Parliament has made specific provision to withdraw any of the of that jurisdiction from the board or tribunal. A very difficult thing to do once you've found it, I would say. And then the last issue they dealt with was whether or not a tribunal has the jurisdiction and authority to actually engage in consultation itself. So step one then is just to go through the two really that I'd focus on would be the power to decide questions of law, and then whether or not tribunals can actually do consultation with a view to discharging the Crown's duty to consult. So you'll either find the power to decide questions of law explicitly within the legislation, like in the NEB Act, it's very clearly stated under their section, I think it's section 12, that for the purpose of this act, it says the board has full jurisdiction to hear and determine all matters, whether of law or of fact. And so that's the kind of language you'd find. If you don't find it explicitly, then you look to find it implicitly, and those sorts of factors are set out by a case from the Supreme Court of Canada called Martin. Look to the statutory mandate of the tribunal being considered and whether deciding questions of law is necessary to its mandate, to discharge its mandate effectively. Look for other things as to the nature of the tribunal or commission. Is it adjudicative? Does it take in facts and make decisions based on their on the law that they govern? To wrap it up very neatly in a nutshell, it's not a difficult thing to find the implied power to decide questions of law in a given tribunal. That is, in fact, almost by definition what they're empowered to do. They regulate. They receive applications for licenses. They hold hearings to look at environmental impacts of proposed projects. Sometimes they hold hearings, but they weigh facts against the law that they administer, and they make decisions based on that law. And so this sort of evolves from, or is a moving away, I think, from a historical approach being taken to try to characterize types or categories or questions of law to narrow in on what specific issues a particular tribunal is suitable to discharge or to address. As distinguish those types from questions of law that belong within the exclusive purview of courts. That sort of reasoning is broken down, and that was discussed in the case I mentioned before, Martin, where the court said, there is, and this was Justice Bastarash, there is, in my view, no need to draw any distinction between general and limited questions of law, as was done in the past. An administrative body will normally either have or not have the power to decide questions of law. And as stated above, administrative bodies that do have that power may presumptively go beyond the bounds of their enabling statute and decide issues of common law or statutory interpretation that arise in the course of a case properly before them. So Martin is the leading case on whether administrative tribunals have the power to decide questions of constitutional law. And then Paul is the case that dealt with Section 35 rights and noted that power. And the legal policy behind this, which is helpful, I think, to understand. This was discussed in a case that I argued at before the Supreme Court of Canada, actually, in Tranche-Montagne, a case involving human rights law. And there was a neat little summary there where the Supreme Court said, the presumption that a tribunal can go beyond its enabling statute exists because it's undesirable for a tribunal to limit itself to some of the law while shutting its eyes to the rest of the law. The law is not as easily compartmentalized, and I think that jives nicely with the comments that Chris was making about how you can't compartmentalize things, you can't narrow and separate these issues out into silos. The law is not so easily compartmentalized that all relevant sources on a given issue can be found in the provisions of a tribunal's enabling statute. Accordingly, to limit the tribunal's ability to consider the whole law is to increase the probability that a tribunal will come to a misinformed conclusion. In turn, misinformed conclusions lead to inefficient appeals or, more unfortunately, to the denial of justice. And I think it's important then to understand that once you've found that the tribunal has the power to decide questions of law, whether explicitly or impliedly, the law tells us that it follows that the tribunal then is obliged to decide all of those questions of law that are properly before them. A tribunal does not have the power, unless explicitly provided for in its statute, to defer particular issues elsewhere. To a court, for example, or to another administrative body with supposedly greater expertise in the particular aspect of law under consideration. I'll skip over steps 2 and 3. I just want to talk quickly then, and obviously I'm not going to get to talking about the Adams-Lake case, but maybe we can come back to that a little bit later. The question of doing consultation and the tribunal. This is something that, while administrative boards and tribunals, when they do their work, clearly like the National Energy Board, engaging in hearings and investigations, hearing evidence about impacts, they do carry on consultative work. And that's consultative work that the Crown, provincial or federal, can rely upon in order to assist the Crown in discharging its duty to consult. But I don't think that there are really any tribunals that are currently set up through their legislation to actually engage in consultation with a view to discharging the Crown's duty to consult. They simply, and I could maybe use an example. The Supreme Court of Canada said that to engage in consultation, a tribunal must be expressly or impliedly empowered to do so through its enabling statute. To engage in consultation with a view to discharging the duty to consult fully, a tribunal must have the authority and capacity to address the issues that arise in relation to the duty to consult. A key factor will be whether the tribunal has the remedial powers needed in a given context to address the remedy, that is, accommodate, in order to reconcile competing interests with respect to the issues that may arise. And frankly, I don't know of any such tribunal that would have that sort of power to actually move from dealing with the issues before it in the context of its own statute to actually then engaging in the process of reconciling competing interests with Aboriginal groups and Section 35 rights and the project under consideration. The neat quote from Carrier Sekani on that subject is that the power to engage in consultation itself, as distinct from the jurisdiction to determine whether a duty to consult exists, cannot be inferred from the mere power to consider questions of law. Consultation itself is not a question of law. It's a distinct, often complex constitutional process, and in certain circumstances a right involving facts, law, policy, compromise. A tribunal seeking to engage in consultation itself must therefore possess remedial powers necessary to do what it's being asked to do in connection with consultation. So boards and tribunals, when they're doing the work that they do and the consultative work that they do, are not in a position to be able to actually actively negotiate, provide trade-offs, one piece of land in order to get agreement to give up another piece of land so that a pipeline can go through, that kind of thing. That's not the role of boards and tribunals, and what that means is that provincial and federal crowns have to remain engaged. They can't set up the administrative process, rely upon it to do consultation, and step away completely, the Crown's going to have to remain involved. And the federal Crown has certainly embraced this sort of broader role for administrative boards and tribunals. It's set out in their policy and their guidelines for consultation. And all Aboriginal groups now, certainly when a major project is being considered, are strongly encouraged through correspondence at the outset to engage with the administrative process, with the hearing processes, to ensure that their views are heard. The trick for the provincial and federal Crowns, of course, is to find a way of remaining involved, aware of what's going on, and in the hearing process, so that they're in a position to pick up any issues that have not been addressed through the regulatory process.
Thank you.
Morning. Very difficult to keep comments in 15 minutes, but as you can tell, we have left a lot of time at the end of the presentations for questions, so save them all. So my task is to describe in 15 minutes or less the proponent's role in the duty to consult, and most of my comments are driven by many years of experience negotiating and consulting with Aboriginal communities on the ground. So I'm finding that much of my legal advice differs from a lot of the practical business strategic advice that you can offer clients as well. Most of the case law that is referred to and that you'll read is aimed at the Crown's duty to consult. And we know that consultation stems from the honor of the Crown, its special relationship with Aboriginal peoples, the need to protect and recognize Aboriginal and treaty rights as recognized in the Constitution. We know that the purpose, function of consultation is the reconciliation of their respective interests and the assertion of Crown sovereignty. We also know that the duty to consult is aimed at protecting Aboriginal rights while they are being pursued in the courts and from being extinguished or impacted by development activities on the ground. So from industry's perspective, industry doesn't have this special relationship with Aboriginal peoples. It's not honor-bound, as the Crown is, to reconcile these respective interests. They really want to develop their projects and make profits, in essence. This is sort of the crude reality. But as part of this, I think industry wishes to manage the risks that any development poses when you're developing it on Aboriginal lands, and recognizes that any relationship that's based on trust, respect, and that's mutually beneficial between industry and the Aboriginal communities goes a long way to managing the risks. So what I'm finding is that industry has been very reactive to the case law that's out there, and also as well as to the ministry's interpretation of how the case law should apply on the ground. And by necessity, that's important because it's the Crown, ultimately, that assesses whether or not the consultation activities have been adequate. So there's two aspects to the proponent's role I see in consultation. One is the delegation of the procedural aspects of consultation. And as you'll see in the solid gold decision, and I'll mention that a bit later as to how that particular proponent viewed the delegation. And the second aspect, which is the practical side I find, is the commercial negotiations and the agreements that are reached between industry and the Aboriginal communities and where that fits in with the overall scope of consultation. And I'm finding that these two elements often get blurred. And that's okay when the agreements are actually achieved, because once you get an agreement, I'm finding with Aboriginal communities, for some reason the issue of or the determination of the adequacy of consultation no longer becomes the focus or the pressing issue. But it really becomes the question when agreements are not achieved, what's the assessment? So I've posed a bunch of questions here on this slide, which I think are critical to understanding the role of the proponent in the consultation framework. And looking at the delegation of procedural aspects, When I try to assess what the proponent's role is in consultation, I try to look at what the purpose of consultation is aimed to achieve. So we see industry as having a key role to play. It's their activities on the ground that have the potential to impact Aboriginal and treaty rights. So therefore, somebody needs to be able to assess the scope, scale, of the degree of that impact and the nature of what Aboriginal rights or treaty rights will be impacted by that activity. And that requires someone to do a preliminary assessment, which the law recognizes, as to the nature of the rights at stake and the degree of impact. This I see as something that's very difficult for industry to do unless, like I say, you hire consultants or lawyers or archaeologists, somebody that's going to do a full-on assessment of what the interpretation of the treaty, like Robert was talking about, because it's not simply the piece of paper that says you have the right to hunt, fish, and trap. There's much more to it. So this I see as a necessary element of the Crown's involvement in the process. But in practice, what you find are many of the biophysical and the physical impacts on the ground that are caused by the development activities interact by necessity with Aboriginal harvesting activities such as hunting, fishing, and trapping. And that's by no means intended to be exclusive or exhaustive, but there is a direct interrelationship between the two. And it's industry that can propose ways to mitigate, avoid, or accommodate those impacts on the ground. So this is where proponents' role becomes integral in fulfilling some of the consultation obligations. It's typically identified and mitigated and accommodated through the environmental assessment process, and when your project goes through an environmental assessment process, the Crown, by necessity, will be involved in assessing how the project has been studied and how the effects have been accommodated, how Aboriginal interests have been protected, and at the end of the day will either issue the approval or not, and in essence assess whether the consultation process has been adequate. But when a project does not go through that type of an environmental assessment process and is driven by the proponent outside of a full study or a hearing process, then it becomes, I think, much more critical as to the Crown's involvement and role in understanding how the impacts have been identified and accommodated on Aboriginal rights. So when you look at the aspects of the commercial agreement, I'll jump to that one, and the impact and benefit agreements or accommodation agreements, whatever you want to call it, that commercial aspect of it, does that really fulfill, or is that evidence that the consultation process has been adequately fulfilled? And I think the answer to that really depends. It's a maybe. It really depends on what the purpose of the agreement was intended to achieve. It depends on what provisions you put in there. So, for example, if the IBA or the accommodation agreement is intended to document how the proponent has assessed Aboriginal rights, has assessed the impact on the Aboriginal communities, how it's provided the opportunities, it documents the information sessions that were held, it documents how the Aboriginal interests have been accommodated through mitigation or avoidance or changes in the project development plans, how it documents Aboriginal support. I think that goes a long way as evidencing whether or not the consultation process has been adequate. So it really depends on what purpose that document was intended to preserve. Which really, I believe, then jumps into the question of what's the Crown's role in those agreements. Industry often looks at them as commercial documentations, commercial negotiations, and therefore not intended to be seen by the Crown. They're very confidential. This I understand. But if you're intending to rely upon it through as evidence of consultation, and this is the place where you've documented the accommodation measures, then perhaps the Crown has to, in their ultimate assessment as to whether or not consultation has been adequate, must take a look at those relevant provisions and make their determination. Like I said at the onset, if there is agreement reached with the communities and you've got your letter of support that goes to the ministry that says we support the project, then, for some reason the issue goes away. But in my view, I think the Crown, in their overall ultimate responsibility role for consultation, must look a bit beyond that and determine whether or not Aboriginal interests have been adequately accommodated. So I'm going to jump down to the benefit sharing, which is really the elephant in the room when it comes to the practical side of implementing consultation and developing projects on the ground. And for me, this is probably the most difficult element to negotiate, because you have to come back to the question of what is the money for? You know, how much is fair and reasonable? Why am I making this payment? And how do I advise my client as to what's the appropriate amount? Because as we all know, these impact and benefit agreements are all very much confidential. There's nothing in the law explicitly which states, you know, proponent must pay X to Aboriginal community if you wish to develop the project. So you have to ask yourself the question, what is the financial benefits? What are they intended to cover? Are they compensation for impacts? So if you have physical impacts on the ground, biophysical, whatever, that could not be avoided, that could not be mitigated to the satisfaction of the Aboriginal communities, then perhaps you assess what the impact could be valued at. Very difficult process, and in litigation, for lawyers that do practice in this area, it's very difficult to assess a dollar value for impacts on fishing, hunting, trapping. You know, does hunting include the right to 1 moose, 2 moose, 5 moose? You know, and do you value it per moose, per family? It's very difficult to assess it. So when you're looking at how much to pay by way of an accommodation agreement, compensation for impacts, very difficult to make that assessment. But when you look at what the purpose of consultation is and the intent to mitigate, accommodate, or avoid any impacts on Aboriginal and treaty rights, you know, it's a logical question to ask. If there are no impacts, what's the money for? That's just one way of looking at it. Or you look at it from a strictly commercial perspective. Company wants to come in, develop this project, thinks it's totally fair and appropriate to partner with the Aboriginal community in whose territory my project is situated, in which case then it becomes straightforward commercial negotiations and the dollar amount will be what it ends up being. Or is it, as hinted at, or probably stronger hinted at in the Kuwaitan decision, that treaty interpretation is really about sharing in the economic benefits. And if you use that approach on the basis that, you know, financial benefits are as of a right, that the community is entitled to for your development of your project in their territories, then it also becomes very difficult, because who knows what that sharing in economic benefits is intended to be. What's fair? What's appropriate? Very difficult questions to negotiate at the table when you're really doing it in a bit of a vacuum, in my view. So as I mentioned, you know, when agreements are achieved, the issue as to what's adequate consultation, what the role of proponent is in the consultation process, the involvement of the Crown, not really an issue anymore. But what happens if there is no agreement at the end of the day and industry wants their permit and decides they want to go ahead with the development, notwithstanding the fact that they don't have Aboriginal support? But I think in that case, then you really have to assess whether or not there's been an adequate consultation process. What has the proponent done by way of engaging the Aboriginal communities? What have they done by way of fulfilling the procedural aspects of consultation? What has the Crown done? It becomes a relevant issue all of a sudden. You want to look to the ministry and you'd like to be able to say, well, it's your duty anyway. You know, what have you done? And the Crown, like Chris pointed out, is sort of looking to the proponent saying, well, we thought you were doing it all. And then all of a sudden the proponent takes a look at their log and says, well, all of these discussions have really been in commercial nature because we've been fighting about the money for the past 8 months. And all of a sudden consultation gets lost. And now it becomes relevant as to whether or not there's been adequate consultation. So it's a very important question to ask, not at the 11th hour, but very early on in the consultation process. What are you intending to do to make sure that, you know, you're doing the legal requirements on the delegated procedural aspects as well as your commercial negotiations, which may be all well and good at the end of the day. Big question, will my permits be issued? It goes back to question number 1, has consultation been adequate? Because I think if consultation has been adequate, notwithstanding the fact that you don't have an IBA or an accommodation agreement with the Aboriginal communities, then, you know, depending on the nature of the Aboriginal rights in question, we know that the case law says that, you know, the duty to consult does not mean a duty to agree. And we know that unless it's in certain circumstances, such as strong assertions of Aboriginal title, that veto is also not a requirement of the duty to consult. So question number 2 becomes really question number 1. Is there a requirement to continue post permits? Of course there is. Consultation is an ongoing duty, and notwithstanding that you've hit a brick wall and notwithstanding that your permits may be issued, the law still goes on and there's still a consultation requirement beyond that. And I think that's important. I put this last bullet in because for some reason at 11 o'clock at night I was thinking about it. Where does free and informed prior consent fit into this overall equation? Because it pops up at every negotiating table that I have, and I keep going back, okay, well, where does it fit in? We know that the United Nations Declaration on Indigenous Rights is an aspirational document. We know that it has to be consistent with Canadian laws, the Constitution, how it's been interpreted on the ground. But Canada, I believe, cannot ignore the consequences of having entered into that UN declaration. And I think what we're going to see, and we've already seen it, litigators will be using the UN declaration in litigation in trying to establish what the full scope of consultation and whether or not support of an Aboriginal community is going to be needed. I think we're going to see much more of that. Briefly, 2 minutes, 2 quick cases. Waugashag First Nation versus Ontario and Solid Gold Resources Corp. Sorry about that. Recent case here in Ontario, which really went to what's the proponent role in the consultation process. Solid Gold felt that they did not have the duty to consult because it's the Crown's duty to consult. So notwithstanding the fact that the ministry indicated to Solid Gold that they should consult with the Waugashag First Nation, there was no evidence of any consultation whatsoever. Ontario did take the position that they delegated operational duties of consultation to Solid Gold, which weren't fulfilled. Not quite sure what the operational component means when it compares to procedural, but I'm sure we'll see more of that as litigation unfolds. And the Waugashag First Nation had an interesting element to their treaty rights because the MNR the Ministry of Natural Resources had determined previously that these lands had a cultural heritage potential, which elevated, I think, the importance of the impact on Aboriginal and treaty rights. So briefly, the injunction sought by the Waugashag First Nation to prevent the exploration activities from continuing was successful. They got a period of 5 months, or 120 days, sorry. It touched on earlier principles. Consultation is upstream, the importance in the overall mining sequence. There was a serious issue to be tried. It looked at the question of whether the Mining Act here in Ontario is constitutional. The court wants to hear that. And the interesting comment about the proponent's role in consultation was that the court said Solid Gold failed to meet industry standards for responsible exploration as set forth by the Prospectors and Developers Association with respect to First Nations engagement. So court recognizes the role of the proponent is important and that required the bona fide dialogue and information sharing between Waugashag First Nation and Solid Gold as facilitated by the presence of the Crown. So I think that's where you're starting to see some more defining. The last case, in 1 minute or less, the Ross River Dene Council versus the Government of Yukon, also a mining case, and the reason why I referenced it is because it talked about consultation again being upstream of the statutory obligation that Chris had mentioned, and that the court balanced the importance of the commercial sensitivity of staking a mining claim. From a practical perspective, the court recognized that consultation can't happen before the mining claim is actually staked and recorded because of the competition within the industry and the obviously the time and money put into studying mineral potentials. So the court in that case made a determination that consultation was required upon the recording of a mineral claim, and as soon as the mineral claim is recorded, consultation begins. And in this case, the court said it was noticed because until you have an exploration program, there's nothing more that they could identify by way of consultation and accommodation activities. So thank you very much.
Thank you.